Hello and a warm welcome to Federal Special Program Capital Beat. Gujarat High Court yesterday refused to stay the conviction and the 2-year jail sentence imposed on Rahul Gandhi by a magisterial court in a criminal defamation case over the Modi surname remark. Now, this was a single judge bench of Justice Pracchak who dismissed this petition, but the basis on which this petition was dismissed, many legal luminaries say that this is something which is very, very unprecedented. Now, let me just read out for the viewers what Justice Pracchak said, and this became the basis for the dismissal of yesterday's Rahul Gandhi's petition. Now, point number one, he says that staying of conviction is not a rule. It is exercised, or it should be exercised, in very rare cases. Then he says that 10 criminal cases are already pending against Rahul Gandhi. The third point he makes is that representatives of people should remain of clear character. Then the fourth point he makes is that one such complaint has also been filed by Veer Savarkar's grandson in a Pune court. And then he says that the conviction would not result in any injustice to the applicant. And of course, the last line of the order is that conviction order is just, proper, and legal, and no need to interfere with the magisterial order, and therefore the petition is dismissed. This is the complete order on the basis of which yesterday's petition was dismissed. And I'm joined by a very senior and veteran Supreme Court lawyer, Sanjay Hegde, who's a constitutional expert as well. So thank you so much for joining on the Federal. And I would really like to understand from you your first thoughts, first of all, on this particular dismissal of petition which came from Gujarat High Court yesterday.
Well, in a lighter vein, I just tweeted that when the history of these times is written, it will be recorded that a North Indian MP from Kerala got disqualified for a speech in Karnataka by judges from Gujarat. That is entirely factually correct. And I don't think it would be either contempt or defamation.
Right. No, but sir, I mean, how would you really decode yesterday's order in terms of the fact I was hearing Mr. Singhvi also, who later on addressed the press conference, and he said that it has never happened in the history of jurisprudence like this. So I would really like you to decode this whole order of yesterday, point by point, if you may say.
Rather than decode the order, what Dr. Singhvi was saying was simply this: that there could not have been a disqualification if there had been a sentence of less than 2 years. So even if the trial court had imposed a sentence of 1 year, 364 days,
right,
there could not have, disqualification would not have been attracted. Therefore, one would have to take it that the court intended not only a 2-year imprisonment, but a consequent disqualification. In the history of defamation law, nobody has got the maximum sentence of 2 years. In the worst cases of defamation, also people have been sentenced to 1 month's imprisonment, 6 months imprisonment, and that's it. So 2 years imprisonment is unprecedented. Now, when you have a judgment like that, which is still up in appeal, the sentence has been stayed, but not the conviction, not the judgment itself. Because if the judgment itself gets stayed, then there is an automatic requalification of the MP concerned. So here before the court was not only the individual petitioner, but also what was at stake was also the right of the people of Wayanad in Kerala to be represented by an MP of their choice. The Gujarat High Court does not appear to have taken that into account.
Okay.
It says, look, this man is so-and-so. He had a higher responsibility. He has so many cases which are pending against him, and therefore I will not stay the conviction. There are many a time as lawyers, we sometimes feel that the judge arrives at the operative portion first, and then puts in a lot of reasoning to justify the operative portion. This appears to be one of those cases.
But Justice Hemant Prachak saying that staying of conviction is not a rule and it must be exercised only in rare cases. Why do you think that line would have been added in that in that order?
No, there in terms of law, he's correct. He's correct. Because you see, convictions are not normally stayed, the sentence is stayed. But where it has been pointed out that there are other consequences other than the conviction. Say somebody is a director of a company, and there is a technical conviction under the PF Act or some other thing like that. Then normally judges take into account, saying that no, what can be imposed is under the criminal law, a sentence of whatever, but other consequences we have to take care. So at least as long as the appeal is not decided, disqualifications should not come into account.
Right. But talking to you point by point, of course, the first point you explained, but then he also says that 10 criminal cases are still pending against him. Now, can that become a basis? There is a case against him in Bihar also. There's a case against him in Pune. So can that become a basis, like as one of the points he's highlighted?
See, none of those 10 cases has resulted in a conviction.
Right, absolutely. He's just accused. Yeah.
He's just an accused. You don't even know who has foisted those cases. And if you take the history of any political leader in India, there will be criminal cases all over.
Right.
So I do not think that this would be a relevant consideration for not staying. And to highlight one particular case, well, the judge may have a private inclination towards one leader or the other. Well, all judges have their own private ideologies. They're entitled to it as citizens. But when it comes to the judicial seat, that is where you have to reason dispassionately, irrespective of your personal proclivities or your ideology, or sometimes even religious sensibilities. There have been cases where judges who, out of religious sensibilities, were uncomfortable with the death sentence, would avoid hearing matters altogether, would ask for some other judge to handle it. I'm not speaking of this case alone. I think that as a general rule, when judges have a particular bent of mind on any particular issue, or they can be seen to be having a certain bent of mind, then justice must not only be done, it must be seen to be done. And very often there are other colleagues who can handle it. I am giving you one more example. You know, in the Supreme Court, whenever there was a Kaveri-related matter, judges both from Tamil Nadu and Karnataka would avoid hearing it altogether. It went to other judges.
But Mr. Hegde, you did point out about religious sensibilities and also the ideological proclivities. In this particular case, a lot of people have been writing on social media about Justice Hemant Prachak that, ideologically it seems he's inclined towards the RSS more. But of course, I'm not going to get into that. But it's just that I made a mention because people have been writing about it on social media. But the third point which he says, and I'm going to ask you on that, is that the representatives of people should remain of clear character. Now, could the judge have avoided this line? Or what is the logic behind this, including this particular line? Does it show his ideological inclination? Does it show his his
No,
kind of sensibilities?
see, a friend of mine was a senior advocate who later became a judge. When he was a senior advocate, he said that judges should be sometimes forced to write their judgments standing up. They should not dictate to their stenos. The judgments become shorter, they become crisper, and mistakes are avoided. So this purity of character and all that, you don't need a judge's certificate one way or the other. The nearest example to this is, I think, a judgment of the Pakistan Supreme Court, which said that Nawaz Sharif is not Siddiq and then hence he stands disqualified. So all those things judges are not called upon. Probably what the judge meant to say was that politicians should be held to higher standards in public life. And if anything that they said or did amounted to a criminal trial, they should expect no leniency.
Right. But Mr. Hegde, Justice Pracchak also mentioned about Veer Savarkar's grandson. Now, that many people say that, why on earth did he have to mention this line? Now, that Veer Savarkar's grandson has registered a case against Rahul Gandhi, be that as it may, but putting that line as part of the dismissal order, how justified or how fair is that?
Please go through the records of the case. I don't think Veer Savarkar or Barrister Savarkar was anywhere in the records, or any of these other other cases pending was anywhere on the record. So I don't think any comment was called for. This is something which goes beyond the record, not put to the accused, and hence an appellate court, if required, could possibly expunge all this.
Right. And then towards the last, he also says that this conviction would not result in any injustice to the applicant. Now, I really don't know what to say about this line. And what would you rather say?
Well, I would. That is where I think you see, where you write the conclusion first, and then or you decide the conclusion first, and then rationalize it backwards. Yes, the fact that Mr. Gandhi has to stay away from a Lok Sabha, which also doesn't function all that well, may not in the judge's eyes amount to much inconvenience or injustice. But at the end of the day, we are a parliamentary democracy with 543 MPs. Each Lok Sabha constituency represents probably more people than are available in many nations who are part of the UN. Now they require a voice in the national palaver, and that is what this country operates on. To say that we will not stay the disqualification, I think is a bit too much. You must remember that when the Allahabad High Court, after an elaborate election trial, then set aside Mrs. Indira Gandhi's election as an MP. When the matter came up to appeal before the Supreme Court, and it was a single judge who was sitting in vacation, Justice Krishna Iyer then came out with a formula to see to it that things continued and that the constituency was not unrepresented. That continue as a member of parliament, do not draw a salary, do not vote. So there are ways, and it is not as if these precedents are not available. But yes, if you feel very strongly about it, then, judgmental faculties sometimes get impaired.
But Mr. Hegde, when you see orders like these, obviously when the history of certain judgments, and many judgments have been written, people quote judgments which have taken place. How do you think that order will be, this particular dismissal order would be taken? Because it comes from a Gujarat High Court. And people do, talk about in condescending tones about the orders given by the magisterial courts, by the Sessions Court. But here you have a Gujarat High Court dismissal order, which is going down as an example. How will people really quote this example as?
I don't know. I may quote it in a particular manner. There will be others who will say that notwithstanding the, I'm again quoting from social media, the ecosystem and this and that, the judges of Gujarat stood up for Gujarat. Well, there could be more than one view on this. But at the end of the day, it is not very inspiring in this country that a high court which is a constitutional court on par with the Supreme Court. It's only that the Supreme Court has appellate functions. That a constitutional court must write judgments which can be so easily commented on, whose flaws are so apparent.
You've used strong words there, but what is the probability now in the Supreme Court, Mr. Hegde, when the matter is being brought to the Supreme Court? Do you think that at one go, probably this entire thing will be demolished and probably Rahul Gandhi's conviction would be stayed with immediate effect?
I've practiced long enough in the Supreme Court to tell you that, nothing is certain till the final judgment is actually pronounced and signed. If you're asking me as far as the process is concerned, I expect that the Rahul Gandhi and his lawyers team will be moving the Supreme Court either this week or soon thereafter. By the time that then it comes up for hearing, another week thereafter. At the first hearing, once the judges are satisfied that there is a case to be answered, they might issue notice to the other side, because you must remember that this is a private complaint. The complainant may not choose to be there on the first day of the hearing. So a formal notice would have to go, that person would have to put in his replies, and only after replies and everything are put will the matter be ready for a hearing. So as I was telling some others, that I expect that the monsoon session of the Lok Sabha may have to carry on in Mr. Gandhi's absence.
Okay. But what about the next session? And of course, people are saying that will Rahul Gandhi be able to contest the 2024 elections? That is also that is something which everybody is looking forward to. So can that happen before that?
Well, again, you're asking me to predict things. And especially, you must also remember that the Supreme Court does not sit unbanked on it. When you see the composition of the benches, then you may have a reasonable idea as to where a matter is likely to go or what is likely to happen. As far as I can see, if Mr. Gandhi was not allowed to contest elections, there would be several questions on fairness of the elections themselves. But it would also be an opportunity. Afsar mein apada mein afsar, because especially when there are questions on Mr. Gandhi being prime minister, this, that, or the leader of the opposition front, there will be so many more possibilities. So it would probably help the cause of opposition unity.
But in context with the bail cases, one of the senior Supreme Court judges said that, why do the Sessions Court judges, they sit over bail? And he pointed out recently, and pretty recently in the sense like just about 3 or 4 months ago, he made a mention of this fact that, these kind of judges should be sent to the judicial academies to reconsider what kind of orders they have given. Now, when orders like these come, is there a way that Supreme Court or maybe the Chief Justice of India can take into account judgments like these, haul up the judges? Can there be some action for such faulty judgments? Can the judges be penalized?
No, there can't be action against such judges, at least judges of the High Court, because they have constitutional immunity. So at best, there can be a friendly rebuke or a warning much later. And the way I've seen the judgment system work is that judges are fiercely independent. They like to call it as they see it. And their brethren sometimes also find it easier to say, oh, it was only Judge so-and-so being this, don't taint the entire institution just because such and such judge said that. So, yes, there can be like a quiet off-the-cuff comment somewhere that, oh, now you've passed your problem over to the Supreme Court. We didn't expect things like this. Maybe somebody would tell them, maybe somebody may not tell them.
Right.
But there is a problem. There really is a problem here. And that's where I'm not speaking of all these high-profile cases. But what happens is that wherever there is, shall we say, media attention on a matter, judges sometimes find it safer to say no, so that it can go up in the appellate ladder, and somebody can correct them and say yes. Sometimes, you know, I have been told that there were that when judges were asked about some particular matter or the other, this is not one of those high-profile matters or the other. So the judge says, yes, I have sympathy for you, but I can't do anything because people will say too many things. What I'll do is I'll write a very bad judgment. It will be set aside in appeal.
But Mr. Hegde, coming to the larger picture and the usage of criminal defamation, what would you really say in context with this particular case? Because Mr. Singhvi also in his press conference said that it's not only about Rahul Gandhi, but it is about the larger freedom of expression. Now, do you think that the politicians, when they speak in rallies, looking at what has happened to Rahul Gandhi, will this order act as some kind of a deterrent, or one would still wait for the Supreme Court to pronounce something and dismiss all what has been said by the Gujarat High Court?
Well, I do expect that if not the politicians, the legal cells of various parties would be ready.
Okay.
They would have come. They would have draft petitions and applications and complaints ready. So then we might not have Mia Musharraf and James Michael Lingdo being bandied around. So that might also happen. We don't know which way these things will evolve. But you see, this very section of the IPC 499 was challenged by Rahul Gandhi and a whole host of others as being unconstitutional. But the Supreme Court has already upheld it.
Yes.
In Subramaniam Swamy's case.
Right.
So the constitutionality part of it, nothing can be done judicially. And the Supreme Court upheld it because the Constitution in itself made provision right from the beginning, from the First Amendment.
Right.
It made an exception for defamation. Yes, it is time that Parliament considers whether criminal defamation should remain a crime, or you should make it just a civil wrong and possibly increase the compensations.
Right. But what about the freedom of expression, sir? Like this freedom of expression is also there that, you know, did Rahul Gandhi say something which was really hurting to the OBC community or the Modi community as such, what he said, that all people who have their surnames as Modis are thieves. This is what exactly Rahul Gandhi said. But uh, was it so heinous? Was it so hurting what Rahul Gandhi said?
No, forget the heinousness or whatever. The first question are Modis a collection of individuals as has been laid out within the section? The section speaks of a collection of individuals.
Right.
Now, what it then meant was possibly companies, partnerships, and things like that. But to say that, if something is said about a Modi, every person who's got the Modi surname has a right to file a criminal defamation is stretching it a bit too far. That would mean that, if somebody were to say that the minister Anant Hegde's statements are on communal issues are so bad that Sanjay Hegde could file a complaint saying that you've called all Hegdes communal. That just can't be. Then what happens if somebody's name is Singh or Sharma? So then Yo-Yo Honey Singh can sue for something said about Manmohan Singh.
Right.
Is that where we are getting to? The interpretation of the section itself by the two courts, I believe, has gone way beyond the intent of the framers.
Right. But when the Supreme Court, Mr. Hegde, gets into the merits of the arguments, is the Supreme Court really going to ask a person like Purnesh Modi that, now should you not prove how the Modi community was damaged? This is a question which was raised yesterday as well. And will the Supreme Court not ask this question?
See, the first thing is that the appeal is still pending. The appeal is still pending in the High Court. It is pending before the district judge in Gujarat. It's only, and that appeal, all these questions will have to be gone into. The Supreme Court will be only considering the question of whether the conviction itself ought to have been stayed in the meanwhile. Right. By the time the appeal is heard, and from the district judge, it then travels to the High Court and then travels to the Supreme Court. That's a long way off.
Right. One last question, Mr. Hegde, and then I wind up the interview. So all in all, the first look of this particular order, the particular petition which was filed by Purnesh Modi, does it look like a very, very frivolous, a very lightweight, misdirected and politically motivated petition?
Well, Mr. Purnesh Modi is entitled to have a high opinion of Modi's. Okay. And as far as I am concerned, I can say that, yes, the outcome of this petition is that we shall now have to say His Holiness Nirav Modi or His Highness Lalit Modi, that they are all such exalted people, that they are all honorable men, and so are all Modi's honorable men.
But the very look of it, do you think that Rahul Gandhi, of course, not getting into the legal bit, but do you think that he's been penalized just because he opened his mouth, he spoke against people like Nirav Modi and the
Lalit Modi?
Lalit Modi, yes. And of course, Adani as well. Just before he was disqualified, he made that big speech where he flashed the poster of Adani and Narendra Modi's sitting together in a flight. Is that the price he's paying for?
That is a conclusion that he may draw, or people in his political party may draw. I would prefer to stick to the facts, and I would prefer to say that the message that I get is that Nirav Modi is an honorable man, and that Lalit Modi is an honorable man, and that if you say anything about these two Modis, you are likely to have Mr. Purnesh Modi file another defamation.
Okay, so your message is loud and clear, and you said it in very, very clear words. Thank you so much, Mr. Hegde. It's always wonderful having you on the program. And one appeal to the viewers who are watching this interview, subscribe to our channel, send us your feedback, and stay tuned to the Federal. Thank you. Thank you, Mr. Hegde. Thank you so much.
Subscribe to the Federal's YouTube page for more news and updates.